So we have an important update in a challenge against the ATF's pistol brace rule. The Trump DOJ recently agreed that the Biden pistol brace rule is now vacated nationwide, but in a new motion that the Trump DOJ filed, they admit that they may still be able to enforce their interpretation that braced pistols can be SBRs under the NFA and GCA. So this is some surprising news. So let's break down what just happened in this case. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. You can also turn on the notifications, turn on all notifications, because that helps to ensure that YouTube will actually send you these videos once I release them. Now, as I mentioned in the intro, we have some important news in the battle against the ATF and their current restrictions on brace pistols as SBRs. The Trump DOJ recently stipulated to the Fifth Circuit that they have agreed with the plaintiffs to drop an active appeal that was going on against the Biden pistol brace rule. The prior nationwide vacatur of the pistol brace rule was appealed to the Fifth Circuit by the Biden administration, and the administration sought to reverse the nationwide block that was put in place by a lower court. However, once the Trump administration got control of this case, they decided to settle that case and dissolve the appeal in the Fifth Circuit. Recently, multiple pistol brace lawsuits have been dropped as moot because of that, but now there is one case filed by DOJ and the state of Texas, which is asking for the court to not moot their challenge, but instead to allow it to move forward. Instead, they point to the ATF's continued enforcement of the pistol brace restrictions, and they point out that that is a major concern and why the case needs to move forward. Instead of dismissing the case, they ask for the court to issue a permanent injunction, which would block the ATF's current interpretation of the NFA, that essentially braced pistols can be SBRs purely based on the statutory text. This is important because if granted, it would prevent any future administration or even the current ATF from going after braced pistols as SBRs. Now, in this current effort, DOJ is attacking the underlying legal theory behind the pistol brace used, so the theory that was used to put in place the rule, and the goal is to prevent this administration or any future administration from regulating braced pistols going forward. Well, the Trump DOJ just filed their motion to dismiss the case, and they make a very shocking statement about pistol braces, which shows why this case is so important and why it needs to move forward. Now, you may recall that the pistol brace rule was put in place by the Biden ATF originally. That was put in place by Biden and his administration. Multiple lawsuits were filed against that rule, and eventually Judge Reed O'Connor issued a final merits decision in the mock lawsuit, striking down the rule nationwide. That ruling by Judge O'Connor blocked the ATF nationwide from enforcing the rule, but then the Biden ATF and Biden administration decided to appeal to the Fifth Circuit. But as we know, Trump, won the presidency. Eventually, his administration got control of this case, and they decided to concede the mock lawsuit. So in the mock challenge, the ATF agreed that Judge O'Connor's prior nationwide vacatur of the pistol brace rule will now go into full effect, and that the ATF conceded that the pistol brace rule is now vacated. That was kind of the first domino that fell in all of these pistol brace lawsuits, and after that, multiple challenges were then settled with the ATF, agreeing that those lawsuits were now moot because of the ATF conceding the mock lawsuit and that the rule was now vacated. Now, one thing that I've been pointing out is that there are some long game implications to these, decisions to agree to drop the lawsuits. By agreeing with the Trump DOJ to drop the cases, you kind of get this immediate win and you end the enforcement of the rule itself right here and now, but you also lose the opportunity to get a larger, more impactful final merits win, from someone like a court of appeals. Remember that the mock case was only ruled on by a single district court judge who vacated the rule nationwide. And if another anti-gun administration comes into office and they decide to take another crack at a rule or, go after pistol braces, there's only precedent that is happening right now in a single district court in that mock lawsuit. The ruling was also only based on some APA procedural issues, which could be remedied by a future anti-gun administration, or they could try to go around that and just do it purely based on the statutory text. That is where we currently have a big issue with what's going on with this case. There have been situations where the ATF tried to enforce their interpretation even after the brace rule was struck down nationwide, and even after the Trump DOJ admitted that the rule is no longer enforceable. And that is now being brought up by DOJ and the state of Texas in their challenge against the ATF and this whole pistol brace issue. Recently, DOJ and the state of Texas, through AG Ken Paxton, filed a status report in the pistol brace lawsuit, arguing that their case is not moot and that the district court in this case should allow it to proceed forward, and they want the court to issue a permanent injunction against the ATF in their current or future enforcement of pistol brace restrictions. In a recent notice to the court, GOA stated that subsequent activities by the defendants, the DOJ, raise serious doubts about their willingness to comply with this or any other court's ruling. For starters, the rule was vacated on procedural grounds, failure to constitute a logical outgrowth of the proposed rule, not a rejection of the defendant's underlying statutory interpretation. And without injunctive relief, defendants are in a position to simulate enforcement of the rule merely by reference to the underlying statutory scheme defining NFA registered firearms. Thus, without a permanent injunction, the risk to plaintiffs caused by defendants' flawed legal theories still remains. So what GOA and Texas are pointing out in this pistol brace case is that the ATF may be trying to do something kind of sneaky right now. They agreed to drop these pistol brace rule lawsuits, these challenges to the rule that was put in place by the Biden administration. They agree that they are not going to enforce the rule, but they may still intend to enforce restrictions on braced pistols just purely based on their legal theories and their subjective interpretation of the NFA's language. So we were waiting to see, how would the Trump DOJ respond to this challenge, how they would respond to this lawsuit, and recently they filed their motion to dismiss the case. In the recent motion filed by the Trump DOJ, they state that plaintiffs nonetheless suggest that this case remains alive because this court can still enjoin the ATF from enforcing the legal theories underlying the rule, namely that at least some pistols equipped with stabilizing braces are short-barreled rifles under the NFA and the GCA. But plaintiffs brought this case under the APA, which does not permit a litigant to challenge or a court to enjoin the enforcement of legal theories divorced from the final agency action. The only agency action challenged in this case was the rule, which no longer exists as a legal matter. So absent final agency action, this court has no jurisdiction to opine on any legal theories or to grant plaintiffs relief therefrom. Now, that is a very interesting statement coming from the Trump DOJ in this case, because they do not deny that they have a legal theory surrounding braced pistols and, that they are potentially covered by the NFA as SBRs, and they do not make a statement that they will not enforce that theory based purely on the statutory text. Instead, they simply say any legal theory cannot be permanently enjoined by the court in this case. They argue that this was filed based on APA grounds and against the rule, and because of that, they say that this case should now be dismissed as moot. Of course, that is very concerning because, again, you don't have the Trump DOJ rejecting that legal theory. Instead, they say, yes, if we have this legal theory, you can't challenge it. The DOJ argues that this entire case is now moot because the ATF stabilizing brace rule is no longer in existence. They point out that the mock lawsuit has already been found moot and the rule has now been vacated nationwide. And they also point to the fact that other cases have now been settled and found moot. The DOJ says courts cannot issue advisory opinions or rule on legal theories disconnected from an active agency action, especially under the APA, which requires a final agency rule to exist before a court can review it. And they say that since the stabilizing brace rule has been wiped out and wiped off the books, they believe there is nothing left to enjoin, nothing left to declare unlawful, and no jurisdiction for the court to continue this specific case. So that's what's currently happening in this critical pistol brace challenge. This perspective by the DOJ in response to this case is very interesting and in some ways concerning. They do not admit that they will not, enforce the underlying legal theory used to put in place the rule itself. And they do not reject this underlying legal theory or legal view that braced pistols can be regulated as SBRs under the statutory text alone. So now we will wait to see how does GOA and Texas respond to this motion. But again, very interesting to see these statements from the Trump DOJ where they say, yes, there are these legal theories underlying the rule, but you can't challenge them here in this case. So as we get more information and as this kind of unravels more, I will let you guys know, but this is definitely something that we need to keep our eyes on. So again, thank you so much for all of your support. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm. But as always, thank you so much for your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.